whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause. Welcome to The Probable Cause. This is a podcast covering the criminal justice system in Allen County, Indiana, northeastern Indiana, and the state. I'm your host, Jamie Duffy, a local journalist, and to my left is our co-host, Michael McAlexander. He is the Allen County Prosecutor. Also contributing will be my right hand. She's very knowledgeable at navigating the courts, helped many homicide families, and someday you might even get to meet her. Let's hope so, right? Today we will discuss legal immunity. This is controversial for sure, and I suppose it's been going on for a millennia. I was trying to think of examples. I'll bet there are examples of immunity in the Bible. And the one that I came up with is, remember when Judas took the silver? Mm-hmm. Okay. They said, was he granted immunity from persecution and prosecution from Pontius Pilate? This is an interesting topic that we can think about, you know? So I just believe that immunity's been around for a while. But first, we do need to talk about the courts. Mike, what have you got going on in the courts this week?
We do have a murder case that started yesterday. Took all day to get a jury.
It sure did. I was there.
And
Not the whole day.
So they started presenting evidence this morning. It'll go today, tomorrow. I think they're hopeful to get it done tomorrow, but it will go into Friday probably for closing arguments and deliberations.
And we probably should say, since this won't be going up for a few days anyway, that the Tommy Gray murder trial does involve people from other cities. There was one crew working from Louisville. The other one was from Chicago. They were working for ServPro. They were holed up, or I should say, they were staying at the Red Roof Inn when the alleged murder took place. It was interesting today. I was in court for about 30 to 40 minutes of it. They had one of the assistant supervisors up there talking about it. She did not see the shooting, she said, but she said that she heard the gunshots. She saw the crowbar. She said she was in a state of shock. She'd never seen anything like that. So I do want you all to make sure that you read my coverage on that. I will be in there tomorrow and Friday if need be. We have the Deputy Prosecutor Tasha Lee and Rebecca Grove representing the state. Tommy Gray's public defenders are David Feltz and the county's chief public defender, William Labredo. And we hope to have him on our show next week. And that should be a really fun one because we'll have the prosecutor and the public defender. And you know, we might have some fireworks going on. So anyway, I'm looking forward to that. Now on to immunity. What exactly is it? It has been in the news, and I'm going to bring this up first because Mike referred to Ghislaine Maxwell last week as the Jeffrey Epstein lady. She's very well known in the news. She was convicted of sex trafficking of minors. She was given 20 years in prison. However, the House Oversight Committee actually wants to bring her back. She is requesting immunity before she agrees to testify. And her lawyers are arguing that she cannot risk further criminal exposure without formal immunity. They did not give her formal immunity. Apparently, they rejected that request. They said she would only testify if she were granted formal immunity, given the politically charged environment. Yes, we do have a politically charged environment right now, especially about the Epstein files. And the potential for leaks and security risks during a deposition in a correctional facility, which we know did take place in Florida with, I think it's the Deputy AG Todd Blanche. So while they didn't give her full immunity. They have given her limited immunity that will allow her to answer questions about the Jeffrey Epstein sex trafficking ring. My question is, if she's already doing 20 years for sex trafficking, is she afraid she's going to be charged with another crime?
Clearly.
Well, I suppose I mean, one thing about criminal law, the people that are accused, whether they're defendants or just suspects, know what they did and know what they didn't do. Some people may not understand what laws they may have broken, but they generally know what their actions were.
Mm-hmm.
So,
and in this case, yes, everybody kind of knows.
Well, but realize that I mean, that's the whole point of doing trials and bringing criminal prosecutions. We have evidence that we believe supports things, but we clearly don't know. We weren't there as a prosecutor. We didn't observe anything ourselves. We are taking the information that we can gather from other sources, putting it together and presenting it as a case. That's our job.
Right.
But truly the person who's being accused of the acts knows what they did, what they didn't do. In most cases, they know whether that was against the law or not. And she may have information that is unique to her and Mr. Epstein that no one else really knows. I'm sure if they were close, which they appear to be, that they had conversations and interactions and shared confidences that only the two of them would know.
Yes.
So if she is going to present information that could conceivably get her into even more trouble, she'd have to be very careful. And why would she do that without some reward?
And yet I have to say she seems semi-eager to appear. I don't know. Maybe it's just a chance to get out of prison.
Well, that's usually a pretty big motivator on folks, that they want to do anything that will lessen their sentence or remove their sentence.
Right, and there is talk about a pardon, so. Yeah, anyway, I checked into it once we talked about it. I thought, since it is a hot topic in the news, that it might be worthwhile talking about. We do have something called presidential immunity. That's the first immunity I was going to bring up, which shields presidents from criminal prosecution for official acts, but not for unofficial acts. And that's when you get into that gray area, what's official, what's unofficial when he's the president. I mean, where do you divide it? But of course, we don't have to. Here in Allen County, we're not, shall I say that we're not exactly having to deal with that. But we do deal with qualified immunity, which protects government officials from liability in civil suits unless their conduct violates clearly established statutory or constitutional rights. And qualified immunity, from everything I've read, most people just apply that to the police and police misconduct. So,
well, there's other immunities out there. As a prosecutor, we fall under judicial immunity, as most judges fall under for the official acts they do. So if I file something and I make a mistake, I am generally immune from civil liability for that. Many, many years ago, we had a couple of people by the same name, although they had different middle names, and we inadvertently issued a warrant for the wrong one. And
I think I know the last name.
Mm-hmm, and discovered it very quickly. I think it was a matter of about 4 hours from the time that the person was arrested till we were informed that we had the wrong guy. We were able to verify it and get the guy released. We were later sued, but in those kind of wrongful arrest cases, we had full immunity because of attached to, we were doing our function of filing charges. Usually in those cases, and a lot of time it's not the sheriff's fault necessarily. but he will get arrested, or he will get charged with it and sued for wrongful arrest, or the police will, even though it's not necessarily their fault. I think right now, nationally, we have a case in, I think was it Milwaukee, where a judge is accused of assisting somebody who had a hearing but evading the ICE authorities.
Oh, yes.
In the courtroom.
It's a female judge. I can't remember her name.
But that she supposedly led the person and their attorney out the back door, kind of thing.
Right, to avoid being arrested by ICE. Right.
And it's my understanding that she's asserting judicial immunity, saying that this was an official act in her court, and so she shouldn't be prosecuted.
Right, and I have that somewhere in the script. I just can't locate it right now.
Judge Hannah Duggan.
Judge what?
Hannah Duggan.
Judge Hannah Duggan, yes. And that's very a very interesting case, which is actually, they all are.
But back to what you were saying, I mean, there's a fair amount of governmental immunity for normal acts unless it's gross negligence or willful and wanton conduct.
And Derek Chauvin, I don't want to bring up George Floyd again, but I might as well. Derek Chauvin, the police officer who did ultimately take the life of George Floyd, or it was decreed that, didn't he try to use qualified immunity? Because that is, many
Probably.
officers have used that.
Yeah.
And I believe in that case they didn't accept it because he went beyond the established statutory or constitutional rights. The jury found that to be the case.
Yes, or that was willful and wanton conduct beyond that of just negligence.
Right. There was also a federal lawsuit here in Fort Wayne that was filed against the city of Fort Wayne and former officer Boyce Ballinger. It is now on appeal, but they alleged excessive force during the 2020 downtown Fort Wayne protests. I happened to cover that. It was in federal judge Holly Brady's courtroom. The jury came out. They found in favor of the plaintiff. They even awarded the plaintiff $80,000. They said that Boyce Ballinger, he used improper arrest tactics and unlawful force. Basically, the man was coming across the Martin Luther King Bridge, was not at the scene of the protest yet. He was taken down by the officer after he believed that Lucas Williams fit the description of somebody that they were chasing. And it was very interesting to sit there and listen to the testimony and listen to his attorneys, but the jury ultimately found him guilty of that. Can I use the word guilty in a federal lawsuit?
Liable.
Liable, thank you. And I always look to him for, that, and $80,000, but as I said, it's on appeal, so I don't know if he has received that yet or not. So, and then we also have something that we might even have to deal with here, and that deals with sovereign immunity. It prevents lawsuits against a state without its consent. The doctrine stems from the idea that a sovereign entity like a state cannot be sued without its permission. I thought at first they were referring to a state as in a country, but I believe that it would also be the state of Indiana, which you represent.
Yes.
So
in different capacities. There's a lot of ways to represent the state of Indiana.
So, in other words, when you get immunity as a prosecutor, would it fall under the umbrella of sovereign immunity?
Well, I think ours is more under judicial immunity, because we are performing a judicial function by bringing charges to commence a criminal prosecution. But sovereign immunity, if you've ever heard of the Tort Claims Act, normally the sovereign is immune. The king was immune from any wrongdoing. But
is that what we call the royal prerogative?
I think that would be accurate.
Okay.
But what we have done is recognize that there are times when, the sovereign does make mistakes. Whether that's not filling a pothole and you break your axle going through a pothole in mid-March in Indiana.
Not unusual at all?
So there are some things that we allow, but we have protections built in for the state. So like in Indiana, there's a Tort Claims Act, and if you believe a governmental entity did you wrong, you have to file a notice of tort claim within a certain period of time after the incident. Usually it's a lot quicker time frame than what you would have on a normal statute of limitations for a personal injury accident. The idea being that you have to notify the sovereign that they've made a mistake early in the process.
Yeah, I forget what the turnaround time is, but it is very quick.
It's,
You better get on.
I think ours is 180 days.
Yeah, I believe that
general.
is. It's right. So 180 days, folks, if you get a pothole, you got to get down there and file your lawsuit, probably get an attorney to do it. It's probably the best way to do it in a tort
Well,
claim.
and there are other things. Recent legislation in the last few years, there was a lot of controversy about, usually involved with drug cases, but forfeiture actions, where we arrest somebody in a drug transaction and we find several $1,000s on them. We have the ability to forfeit that money. There was a famous case from about 10 years ago that went up to the U.S. Supreme Court out of Anderson, I believe it was, Madison County, regarding the seizure of a Range Rover.
Nice
and-
car.
Yeah, and the question became,
The drug dealer has a nice car.
was
Yeah, there was a federal case here that the one of the defendants had a gold-plated AK-47.
Oh my God. How long ago was that?
That's been within the last probably 4 or 5 years.
I don't know why I didn't know that.
so, I mean, over the years, we've done a lot of forfeiture cases. There have been other forfeiture cases, but there was a concern. At times, we were accused of policing for profit. There was a book put out, I think, by that title that accused a lot of law enforcement of going after things that way. So some of the forfeiture laws were tightened up and requiring either a greater connection between the unlawful activity and the money. And a lot of times we were having to prove how there was no legitimate means of support. And the person the money was seized from might be saying, well, I got an inheritance, or I won the lottery, or
My
I got
uncle
a
just
job.
loaned me the money.
Yeah. So we would litigate those kinds of issues. But as part of that, we're now required to file a notice much earlier in the process when we seize stuff so that people can mount their defense and gather their evidence to prove their position that they rightfully own it.
So when I read the probable causes on drug dealers and alleged drug dealers, it will usually say exactly what the amounts of the drugs were, what specifically the guns were, and exactly how much cash. It indicates whether it's cash. Usually it's going to be cash, right? And that's probably in the probable cause a good way to stipulate, hey, down the line, we might have a forfeiture case.
Yes.
Yeah, drug dealers stopped taking checks years ago.
Good one, my right hand. Okay, so you can tell she's feeling better with a smart remark like that. Immunity in a legal context refers to an exemption from legal obligations, such as a liability for damages, punishment, or prosecution that would otherwise apply. It can be granted in various situations, including criminal and civil cases, administrative proceedings, and legislative inquiries. In a sense, immunity can be seen as a legal maneuvering tactic employed by the government or other parties involved in legal proceedings to achieve a particular outcome. We did have a case here that I covered a couple weeks ago. I'm not going to say this person's name, but it was the case, both of the men who ambushed Brandon Golden and Daisha Fitz was Damari Haywood and Devontae Trevier, right? But there was a third person involved who was sitting in the casino on Bluffton Road, who was taking photos of the two victims and he was sending them to the two that I just mentioned, who ambushed them at Airport Expressway and Lower Huntington Road. He has never been charged with a crime. So without naming him, because he's in the probable cause, he was in court testimony, I do have the right as a journalist to name him, but I'm just not going to, because I saw him testify. Did he get immunity? Want me to whisper?
I don't believe so.
Really? So what would have compelled him to come tell that story? Because Tyree Barfield, who was Devontae Travier's defense attorney, said he's just as guilty as the others.
Well, if he'd been given immunity, that probably would have been brought out at the trial.
Yeah, I'm trying to think. I think
Wouldn't it have to be brought out at the trial?
Generally, I mean, if we make a deal with someone to reduce their sentence or not prosecute them, we have to provide that information to the defense. And
Make a deal with someone other than their defendant.
right. And in order for the jury to evaluate their credibility,
right.
The defense will usually, actually, if we do something like that, we usually will bring it out in their direct testimony to say, okay, in return for you testifying here today, you've been promised that, or your sentence has been modified to something else, or you haven't been sentenced yet, but instead of being charged with attempted murder or aiding murder, you're being charged with aggravated battery, or some variation.
Reduced, yeah. So I think Tyree did bring that up. I wish I had my story in front of me because I'm sure I put it in. But I do.
But when those kind of agreements are done, they are disclosed to the other side.
Right.
Because if we didn't do that and they came out later, we'd have the case reversed.
Aha.
So.
Right.
So what he's saying, Jamie, is there was no immunity in last week's trial.
He doesn't believe so, but I think if I go back to my story that I will find out that yes, he did. Because the last thing he texted to those guys is, because this is when BG and Daisha Fitz pulled out in that gold SUV, he said, he on Winchester. I remember that quote. I looked it up last night, right? So he was telling them, okay, they've left the parking lot. You're free to ambush. So, and they were both convicted of that, so I can...
Doesn't mean that he was given immunity to testify to all that. He may have just testified to all that.
Right. So I'm going to have to go back and check my story because I don't remember. I do believe Tyree brought it up, but I have to make sure. That is Tyree Barfield. He was the public defender in the case. So here is how immunity can function as a legal maneuver. You have such a thing as compelling testimony. Prosecutors often use immunity as a tool to compel individuals to testify or provide information that might otherwise be self-incriminating. For example, and this might be the case in the one that I just talked about, a minor participant in a crime might be granted immunity to testify against a more significant figure assisting the government in their prosecution. Now, if you go back to Ghislaine Maxwell, she's got that French first name, Ghislaine, it could be that she's looking for more immunity because she wasn't exactly a minor participant, but, and I would argue that they were both significant figures in it, but she might want that immunity for that reason. It's like, hey, whatever I bring up, I don't want another crime. I don't want to be, I mean, there's over 200 girls in that, or, former girls, they're now women, who had to sign non-disclosure agreements in that case. And there's a lot of us out there that think that that should be removed.
Well,
NDAs.
People that are convicted usually want to see their sentence reduced or overturned. what information she has. I mean, she may very well, as I said earlier, be aware of other crimes that she committed or Epstein committed that have not been charged. She may be able to provide details that no one else would be able to provide. But in order to disclose those, she probably wants, at a minimum, a reduced sentence.
Oh, she's definitely, well, she's, the word is she's looking for a pardon. I don't know. I think that would be a dangerous thing to give her a pardon. I really do. After what she's accused of and what she did. But, so another reason.
What did she do? What has been proven that she did?
I think she was convicted of aiding in sex trafficking with Epstein. But again, who knows the full extent of what all they did?
Don't you remember the woman who accused her, Virginia Giuffre, just committed suicide like 2 months ago. And she was instrumental in putting Ghislaine Maxwell behind bars. So
I'm not saying she is or she isn't. I'm just saying what has actually been proven or what has she actually confessed to.
see, this is the old right hand coming back here. These were the morning discussions on the way to Wayne TV. And she would, she was my devil's advocate and everything. We would go over the cases, and it would be a back and forth with my right hand. Can't say her name yet, but all right. Yes. I mean, we can look that up because, well, next week we're supposed to do we're supposed to have a third person here in person. That should be really fun. Encouraging cooperation. Immunity can be offered to witnesses or potential defendants in exchange for their cooperation in an investigation or trial, potentially aiding in building a stronger case against other individuals. Would you say that that's done fairly often here in Allen County and northeastern Indiana?
I wouldn't say fairly often. We certainly, probably the most common instance is we will get people that are incarcerated with a defendant, and these guys have nothing to do but chat and talk, and they will sometimes come to us and say, hey, I've got information on so-and-so, and the defense usually then calls them jailhouse snitches.
They sure do.
But
I've seen that many a time.
And do we evaluate that information to determine whether we think it's credible, whether it could have happened? Usually when we have that kind of situation, we will check jail records to see, were these guys in the same cell block? Were they in the same cell? What kind of access did they have?
I would think the defense attorney would want that.
Well, we want it.
Depends on where the guy is.
Yeah, I mean, we need to bolster their credibility.
Right.
I mean, clearly a lot of people are suspicious when somebody who's already in jail for something suddenly comes up with, this guy confesses to me that he killed somebody. Most people are going to be a little suspicious of that testimony.
Yep.
So what we have to do is see, are there ways that we can provide a foundation or corroboration for it to show both that it could have happened. I mean, if it turns out they weren't even in jail at the same time, then we know where we're getting told a fib. If, on the other hand, they were roommates or cellmates for 2 months.
Or in the same block, and they're all set.
I mean, it's very possible. We may be looking to see, did other inmates or jail staff see them together? Did they appear to be buddies? What things are there that they're telling us? Is there anything unique that only the person who did the crime would know about? So you have to look at all of those things that can help you corroborate. Because
Do you ever turn these guys down? Just say,
Sure.
Oh, okay.
I mean, sometimes you have people that their record is so bad that their credibility is non-existent, and there's really nothing you can do to make them better. There are some people that really cultivate their ability to be a snitch, if you will.
In other words, they're liars.
Well, I would
Such
say
a dirty
that
word, but
They're good liars.
I just
What
read
kind?
I just read a novel by former FBI director James Comey
right.
that a central part of that was using an informant who had played the game long enough that he was put in with kind of a Jeffrey Epstein kind of defendant.
Ooh, sounds
And
interesting.
he was not working for the government at the time, but he knew how the government handled informants. So he started befriending this other person.
The sex trafficker.
Yeah, so it didn't involve the government at that time, even though this guy knew that eventually the feds might be interested in what he had. So,
Kind of like entrapment.
Very
well,
clever.
that was the whole issue on it. But because he had the knowledge of how the government operated with informants, he was not actively working with them, but he did the things to ingratiate himself to the defendant. And that became one of the key points of the book, the plot line, as to whether the government then should be held, that he was a government agent, even though he wasn't actively being paid or getting anything from the government at that time. So an interesting
what was
view.
he in prison for?
I don't remember this. It didn't matter what it was. It was unrelated.
See, what was?
Well, and it wasn't a sex crime anyways.
Oh, that's nice. We've had enough of those lately.
It's just a point of
Do you want to say the name of the book? Because people might be listening and thinking, that sounds like a good book to read.
FDR Drive.
FDR Drive. I like that.
So interesting book. I will
That's
also
in New York
say
City, right? FDR Drive. I know we're right where it is.
it also another key point in that book, which I found interesting, coming from the former FBI director who presents as very pure,
Controversial.
has to do with a violation of a privilege that is not disclosed in the book. And the person essentially gets away with it.
Ooh.
Yeah, it's a little disturbing from a,
We should ask him to come on the podcast.
I think he's a little busy right now.
Oh, we can do a Zoom. It's fine. I'll have to read the book though. I don't mind. All right, so the other one, sort of the same thing, is shaping the case. The type and scope of immunity granted can significantly influence the direction and strength of a label. So it's the type and scope of immunity, which we did talk about, full or limited, impacting the prosecution's ability to use certain evidence or the defense's strategy. So then we go to different forms of immunity offer varying levels of protection. One of them is transactional immunity, which they call the broadest protection. And I know you would know what that is, even if we don't.
Well, sometimes you give immunity for everything. Other times it's very limited to the specific set of facts or circumstances. And just in general, the trick with immunity, and people say, well, you can get them to talk. And people get this confused. We've talked about grand juries before.
Right.
And I think I've mentioned that just because you're in front of a grand jury does not negate your Fifth Amendment rights not to give a statement that could tend to incriminate yourself. We just saw that on the national stage when a congressional committee subpoenaed a bunch of former White House staffers under President Biden, that they were kind of looking at, I believe, President Biden's health. When did people know that he, if he was deteriorating mentally? And I think it also was kind of a tangential examination of who had use or access to the auto pen to sign pardons and executive orders. And it was very interesting that many of those staff members claimed the Fifth Amendment. They refused to answer on grounds that it would tend to incriminate them.
So is that going to go on forever, or will they eventually?
Well, this
have to
is
say?
where, if somebody takes the fifth in that regard, the prosecutor, or in this case, the congressional committee, their remedy is to offer the witness immunity, which essentially says whatever you tell us in this context, and you set out your parameters of what we're talking about, we won't use against you in any criminal prosecution.
Mm-hmm.
It's similar when we talked about Garrity rights and stuff
Right.
earlier, that you need information, and we need this information, it's valuable to us, but we will not charge you or find you criminally liable for what you tell us. Now, the danger on that is you may get information that you don't want. I just had somebody tell me a story that I kind of vaguely remembered coming out of, I think it was Afghanistan, where a member of the military was accused of murdering a civilian. And it was an operation, and they gave immunity to the medic who treated the injured person. Well, the medic gets on the stand and says, yes, I got there, I saw he was still alive, so I stabbed him and killed him, which got the other person charges dismissed. Did it happen? Did it not happen? But the immunity probably wasn't what the prosecutor, that was not the answer the prosecutor probably expected.
I don't remember that one.
And
Did the medic say why he stabbed the man? I'm just going a little further here, that's all.
and even if it's an urban myth, it explains the dangers of immunity.
Right, you're right.
Because what happens, like in a situation like that, you've got the incident, it happened, and it relieves the other person of responsibility. But the other thing it does is that is sworn testimony. It is there forever. You can't get rid of it.
Mm.
It's like when somebody gives a statement, you then have to explain that away for any further prosecution.
But the medic would be charged. The other charges were
He
dismissed.
got immunity.
He had immune. Oh my God.
So that's the danger.
They wanted immunity.
Yeah.
But I think he needs to be in some kind of a psychiatric institution then.
Sometimes there can be other remedies besides criminal prosecution. But the point is that when people talk about, and this kind of goes back to the grand jury, well, bring them in and you can make them talk by giving them immunity. Well, that may be true, but if they then come in and say, well, I did the crime, not the person that I suspect did the crime,
Right.
and that my other evidence goes against, if I try to go after the person I'm originally thinking did it, I've got to give this to them. It messes up my case.
Yeah.
Yeah, that's going to happen. I'm sure there's
So-
other things that mess up cases.
So this is one.
You know what my English friend used to say, there's nothing stranger than other people. So
Well-
it's like,
I mean, there's a lot of things that can go wrong in a case. I had a case, this is not quite immunity, but it's a little bit of tactics. We had a case where we were prosecuting a person for murder, and it was a close case. There was a lot of evidence against the defendant, but he had an alibi, and there were some things that made it a tough.
how long ago was it?
Well, the actual homicide happened in 1990 or 91, but it was tried in the early 2000s. But one of the issues in the case, the defense kept pointing to a couple of people that were subsequently convicted of some crimes, and was trying to say that they did this. It was a triple homicide. That these two other guys did it. Well, the one guy took the fifth and wouldn't testify. The other guy agreed to testify, but because of the nature of the testimony, we took his statement outside the presence of the jury under oath, and he started talking. And
That wasn't like just a deposition. It was
like a quasi-deposition. Everybody was a little suspicious of his. So the defense walked him through his testimony. There were many things that were said that we were very suspicious of, but this was in the middle of a trial. So we were doing this on a Friday afternoon. We expected we'd rest on Monday or Tuesday, and he'd be a witness for the defense then a few days later. So he goes through his story, which we found to be full of a lot of holes.
okay.
But rather than cross-examining him at that point in great detail, we tactically decided that we would hold off, knowing that we would get a shot at him at in front of the jury, and we didn't want to alert him to where we were going. Well, he then, a few days later, takes the stand for the defense. As he's getting into, after the preliminary questions, he gets to the point where they're starting to ask him about the incident, the homicide that we're on. And he clams up and says he can't say the name and he can't talk. He's dismissed. We moved to strike his testimony that had been done that far. The court granted that. We got a conviction on the case. On appeal, the appellate court overturned the case based on the fact that he had become unavailable when he said he wouldn't testify, and that his testimony from a few days earlier should have been admitted. It didn't seem fair to me then, and it still doesn't. But that was the ruling of the Court of Appeals, and
So they actually went against the judge?
And so that was an example of you put somebody on. In this case, we held back from cross-examining him, which hurt us down the road because we were unable to really attack his credibility because he then wasn't available for us to cross-examine. And we were stuck with the statement he gave. But that is kind of a parallel to the whole immunity thing.
Did you actually want to introduce his statement?
No.
You didn't. Okay.
I would have wanted to gone ahead and cross-examine him based on what he said.
Right.
But we made a strategic decision that turned out to be wrong. But with immunity, I'm saying that from the standpoint that once a statement like that is made, it's out there and you're stuck with it. So you better be pretty sure about what you're going to get. That's why we do generally what's referred to as a proffer, where we will go and ask, and it's a statement that we can't use unless we come to some agreement with them. But they will give us a statement about what they know. And then if it looks like it's something that we can use, then is usually the time when we will agree to some limited immunity.
I just used that word too, proffer. I can't remember what case it was. I've written a lot of them lately. Okay, so one of the things that's come out of the research that I did here is that there are risks and limitations to immunity. It says immunity can be beneficial, but it's essential to understand its limitations. For instance, it doesn't protect against perjury or necessarily shield individuals from civil liability. So I don't know if either one of you want to jump in on that. Talk about the perjury. I found that to be interesting.
Well, you realize that normally you are in a limited information situation. So the statement they're giving under oath is there, but if you already knew the information, you probably wouldn't have offered them immunity in the first place.
Except for if it would be beneficial to your case.
Well, but it's still, to prove perjury, we have to prove it was false.
Right.
And that's the danger. If we already knew everything, we wouldn't have offered immunity in the first place.
Right, because then you are taking what they're calling the risk.
Mm-hmm.
And the defense might be some smart cookies and figure it out.
Right. And that's where, and this is the part I think that is very frustrating for victims' families when, and this is a bigger picture than just immunity, but the nature of crime and criminals is they do talk. Mm-hmm. They do brag about what they did. And so, especially
the young ones
right.
on Facebook.
And especially in murder cases with no statute of limitations, new information does come forward. And so maybe we don't have the information today, but there may be things that come up later. So we are reluctant to go forward with a bad case if we think it has the potential to get better. And sometimes it's as simple as these guys may very well talk, or somebody that knows something or help participate gets in trouble and bargains his or her information against the prime suspect. So that's why we do that. To the families, I'm sure it looks like that's just an excuse by the police or the prosecutor to avoid charging my case. And I can certainly see why people would feel that way at times. But there is a very legitimate reason. It's why we do have cold case squads. And I think not just here, but throughout the country, you're seeing more and more cold cases filed for those reasons, as well as other tech developments that have made getting into phones easier.
Well, yeah, we just had the Muse on Main one. That's a cold case. It was 5 years ago. And a lot of people actually read that story because it's so fresh. The participants in that were very young, very well known in town, amongst all their friends or their enemies. And they were talking, like you were saying, they were bragging about it and telling people at the Huntington County Jail, this was his name, and we had guns drawn, but he's the one that shot, and Cameron Starks has been charged in that murder. And I put in my story, I knew it was Brian Martin. He took it, dusted it off, took another look, and wham, he's,
Again, that's one of the cases that's newly charged, innocent until proven guilty.
Yes, and we know that. But I did notice, I thought, nobody's made a big deal about this thing, and this is a cold case. And by the way, might I say, because we're running out of time, the homicide unit is cooking in this town. They are still at 100%. And it's amazing. And we are going to get the chief on the podcast to talk about that and many other things. But this morning, there was a shooting in Waynedale, Lake Ridge, I believe. And the next thing I know, an hour later, I am reading that they have charged someone in it. I mean, it's almost like they're turning themselves in. They should be giving tutorials to other police departments on how to solve these, because they just have a team it's just unparalleled in America. I don't know why we don't have, I keep saying I'm going to contact the New York Times. It's about time I did. So anyway, there's one last point about immunity, and that is a federal prosecutor can prosecute someone given immunity at the state level, but this person is asking if once all testimony is presented, can prosecutors decide to rescind and prosecute anyway?
Well, probably the most famous case of recent vintage that way was Bill Cosby. Back in, I think, 2004 or 5 or something, he was investigated and for, I think, essentially drugging young women and then having sex with them.
I had a friend who worked at NBC, and she was invited over to his place.
Well,
yeah,
a prosecutor during that time period, there were, I believe, some civil litigation lawsuits going on as well. So he said, essentially granted immunity, saying, I will not prosecute you if you cooperate in these civil proceedings. So he gave a deposition and acknowledged some of the things he did in the civil lawsuit. I think there was a civil settlement. Prosecutors change. Several years later, a new prosecutor tries to rescind that agreement. They end up prosecuting Bill Cosby. I think they had 2 different trials on it. Eventually got a conviction. He went to prison. He appealed it. All along during that case, I kept thinking, how are they getting around that? Generally, to put it simply for prosecutors, a card laid is a card played.
I like that one.
If we give our word, we're bound by our word.
Mm-hmm.
And this sounded like it was more than just a nod and a wink. Yeah, you give that depo and we'll be fine. I mean, if it was only that, I'd say, I can't believe somebody like Cosby has attorneys that would go forward and allow their client to give that kind of damning testimony without a pretty strong immunity agreement. And eventually, the Pennsylvania appellate courts overturned his convictions on that basis.
That's right.
And I thought all along that's what should have happened. I never understood. We even had a couple of the prosecutors come to one of our conferences and kind of do a step-by-step how that prosecution operated.
You had people from Pennsylvania come?
And it was one I never heard the answer of how they got around that, and they did. It was the ultimate answer.
They did eventually, but maybe a judge has to sign off on some of this stuff, right?
Well, a lot of people may have done that and ruled against him, but ultimately, what I thought was right.
So this is the last thing that I found is once the person who was granted immunity delivers their side of the bargain, the U.S. Supreme Court has ruled that such immunity cannot be revoked and that the prosecutor is bound to the agreement that they have made. This is particularly important for the person who has provided testimony that might incriminate them in a crime which would otherwise be barred by the Fifth Amendment. So I guess that's the last word. I did want to say something about, I'm kind of upset about the disruption of language instruction at the public universities in Indiana. And I saw a reel on this young man at Indiana University where my younger boy went, and he's a Spanish major, and he will continue to be a Spanish major because he's still there. He's sort of got like a grandfathered. But I don't understand it. And somebody in the reel brought up that many, many people do double majors. In fact, I think Robert was poli-sci and he did economics as well. But we always pushed languages in the family, and he is using Spanish now. But I'm just begging Indiana University and the other universities to rethink this. It's so important. Mike here was trained to be a Vietnamese translator. I mean, because he had some language. Language helps you throughout your life. And it's made my life much richer. I can go into French courts and figure out what's going on now because I worked and worked and worked on speaking French. I did not grow up speaking French. And so this is my rant for the day. Does anybody else want to sign off on their rant?
I'll pass.
My right hand.
I didn't know that was an option. I'll have one ready for next time, though.
Okay, so I should say au revoir, mes amis, but I'm going to say this has been The Probable Cause. You can find us on www.theprobablecause.com. We have a Facebook page that is dedicated to all my stories, etc. too. And for now, I want to say goodbye. This episode is filmed and edited by Frosty Pictures. The Probable Cause is produced by Maumee Media.
Worried when I crossed the Michigan line, a cop from Steuben County waiting on I-69. A headlamp went out while he pulled me over. Charged me with possession after I rolled down the window.
Now that's skunk.
Indians a trip when it comes to weed. It's like who doesn't smoke or use gummies? Your grandpa, your brother, your rich friend from school? Hell, throwing the whole courthouse and my attorney too. It's time those assholes change these stupid laws. It ain't worth the paper for a probable cause. Sitting on a bar stool in my usual place, this guy next to me said he was looking for some cocaine. Hell, I just sold him an 8-ball with a little piece off for me. But my buyer was a cop? Should have known he was a creep. So I'm a dealer, right? You gotta be kidding. It's a rich man's drug. I just take it because I'm injured. 8 years in Westville with a monkey in my back. There's more drugs in here than you can shake a shank at. One dirty drug test, man, this system's flawed. Undercover screwed me in my probable cause. Street crimes never did me no favors. I'm hooked on Fetty. I'm a junkie, not a felon. Told that son of a bitch on the way to lockup. I can't seem to shake it. I need help, not mocking. What do you want from someone who's been through the system? Drugs all through the house before mom and dad went to prison. Throw me in jail and give me a fine? Someday I'll be dead and away from your kind. Now I'm at the courthouse in front of a judge. Can't say my public defender cares for me much. Crimes are committed on both sides of the law. God help me now with this probable cause. C shift never gets old. Anything can happen when you're out on patrol. You think I'm just eating donuts, man? Give me a break. Nothing on this job is a piece of cake. Lights and sirens activated. This knucklehead wants to chase. Baby mama at the scene just spit in my face. Wife's worried that someday I won't be pulling up at all. You'll read about my killer in a probable cause. She went through my phone and she seen my text. I told her forget it. It was just my ex. She took a swing and knocked me flat. Man, I went wild and hit her back. Judge slapped me with a no contact order. Now she's got the kids and she's staying with her mother. So she started it all and I have to take the fall. You can read my whole story in the probable when I was young. Caught a case for dealing and did my time. Yeah, I got a record, but I was doing fine. Running my own business on the southeast side. Yeah, I got a gun. I kept it on hand. Told the cop my reason, thought he'd understand. In this neighborhood, you need some protection. Attorney thought I could get just community corrections, but the judge decided to send me to prison. Can't get ahead no matter how hard I try. Read the probable cause, it'll make you cry.
Whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause.